Well, my name's David Fanning. I'm the Magistrate of the Neighbourhood Justice Centre. My background is that of a lawyer and also a social worker. I originally graduated in social work and worked in a number of areas, including in mental health, in child protection, and in assistance to families. I was also the Commissioner for Children in Tasmania. We have always adopted an approach of ensuring that anybody who comes before the court gets appropriate assistance, whatever their matter is. And of course, particularly family violence, we've always been keen to ensure that both applicants or protected family persons and respondents get appropriate assistance, and that it's treated seriously. It's crucially important that the person who is the applicant or the protected person gets and has available to them assistance, and that they know that that's available and that it's not just restricted to the day of the court, but that it's ongoing. Other courts struggle to be able to provide the accommodation, have the resources readily available. Well, there are different ways of getting over it, and plainly money and resources, but also being able to readily connect with those community resources is another challenge for courts, and often don't have the time or capacity to be able to do that, because there certainly are a range of different services that do exist in the community and may well have or want to, or be keen to have a stronger relationship with the court, but don't know how to go about it, or the court is not able to establish that relationship. As with the Aboriginal Hearing Day that the NJC assisted Heidelberg in establishing after we'd established it here, and it's been very successful, certainly the NJC is open to assisting other courts in developing the work that it's done, engaging with the community and with services that exist in the community. Traditionally, of course, courts have been, as they should be, arbiters, independent arbiters between parties. The family violence area makes it a little more complicated. It's not as in a classic civil dispute or a classic traditional criminal law dispute between parties come to the court in dispute either with another individual in the community or with the state through the police. And the court decides upon the issues. In family violence, it's a bit different, because it's not just a matter of arbitrating between the parties. And certainly what I think there should be greater clarity about exactly what the role of the court is in family violence, because it does change. Different people have different views and perspectives about, well, where does the court fit in the family violence area? Is it just being an arbiter between the two parties? That's certainly one view, and other views is that it has a much greater role in working with the parties to get them off to services, to get the respondent off to behaviour change programs, and to really, as I say, have a much greater role in fact, even supervising what is occurring in regard to the family violence application and the aftermath. There's a lack of clarity because it's relatively new. Criminal law has been around for many hundreds of years, and so there's been a development over nearly 700 years in the common law jurisdiction in our part of the world to develop the way in which courts deal with it. Well, family violence has not had that amount of time at all. It's really only developed in a real sense in the last decade or so. So of course that there's some uncertainty and some confusion and some lack of clarity about, well, what is the role of the court in dealing with or hearing family violence matters. I think it has the potential to get more murky, more uncertain, more unclear. And I think the court, quite rightly, and I think the court broadly, has had a very limited role, and it's recognised that that's been too limited, but then how broad should it go? Applications have always been civil matters, and I don't really see any good reason to change them. I can see no particular benefit in changing them from being civil matters to criminal matters. The real importance of them is the real significance of whether or not they're civil or criminal is not the label, it's how they're enforced. That's what matters. And that's not the court's role, of course, that's the role of police. Clarity about role and about who is doing what and why actually helps that happen, rather than being overstretched and everybody trying to do everything, because then it doesn't work.